Good evening. We would like to request our esteemed speakers to please be seated on the sofa in front. On behalf of the Center for Discourses on Criminal and Constitutional Jurisprudence, I welcome you all to our second discourse. We are grateful to our previous speakers, Justice Mridul, Justice Bhambani, and Mr. Hariharan, Senior Advocate, as well as Dr. Arun Mohan, for gracing our inaugural discourse earlier in the last year. The Center was conceived with the vision to provide a platform for continuous learning via lectures, discussions, and the like on various fundamental conceptions and principles that are vital for our legal system and its development, especially in the fields of criminal and constitutional law. This humble initiative, undertaken by a group of young lawyers, hopes that in whatever little measure possible, the same might contribute to the onward march of jurisprudence via sowing the seeds of constructive thought. We would like to thank all of our speakers today for taking the time out of their busy schedules to be here with us. I would now request our esteemed speakers to join our founders, Mr. Harsh Prabhakar and Mr. Akshay Bhandari, for the lighting of the lamp. Everybody tell them to stand near the plants. Near the plants? We're giving the thing now. Where is everyone? On behalf of the Center, Mr. Rajat Vadhva, Advocate, will now present a small token of our appreciation to Her Ladyship, the Honorable Justice Hima Kohli. We now request Mr. Parmesh Bali to present a small gesture of our gratefulness to His Lordship, the Honorable Justice Ohri. Mr. Sumer Singh Boparai, Advocate, will now present the same to Ms. Rebecca M. John, Senior Advocate. We are also grateful for the presence and blessings of the esteemed sitting and former judges of the High Court. Mr. Harsh Prabhakar will now present a small token of appreciation to Justice Bhambani. Mr. Pratham Sharma will now present a small token to retired Justice S.K. Misra. Mr. Parmesh Bali will now present a small token to retired Justice Birbal. And Mr. Amish Tandon, Advocate, will present a small token to Ms. Neelu Kohli, owing to her famous green thumb. We will now begin with the lectures. Our first speaker is Justice Hima Kohli. Justice Kohli was born on 2nd September 1959 in Delhi. Her ladyship graduated in History Honours from St. Stephen's College, University of Delhi. She completed her LLB from the Law Faculty Campus Law Centre, University of Delhi, in the year 1984. Justice Kohli was the standing counsel and legal advisor of the New Delhi Municipal Council in the High Court of Delhi from 1999 to 2004. She was appointed as the additional standing counsel on the civil side, Government of National Capital Territory of Delhi in the Delhi High Court, in December 2004. Justice Kohli was appointed as an additional judge of the High Court of Delhi on May 29, 2006, and took oath as a permanent judge on the 29th of August 2007. In 2017, her ladyship was appointed as a member of the General Council of the West Bengal National University of Juridical Sciences, Kolkata, from 11th August 2017. On 11th March 2020, Justice Kohli was appointed as the chairperson of the Committee of the Delhi Judicial Academy. In the same month, that is, on the 26th of March 2020, her ladyship was appointed as the chairperson of a high-powered committee constituted by the Government of NCT of Delhi, in terms of the order passed, dated 23rd March 2020, by the Supreme Court of India regarding the decongestion of jails in all states and union territories in view of the COVID-19 pandemic. Justice Kohli was sworn in as the first woman Chief Justice of the High Court for the state of Telangana on the 7th of January 2021. In her span of about 8 months as the Chief Justice, the division bench led by Justice Kohli disposed of 1,731 cases. She has also been appointed as Chancellor of National Academy of Legal Studies and Research, NALSA, University of Law, Hyderabad. On 21st August 2021, she was elevated to the Supreme Court of India. Her ladyship, in a bench with Justice A.S. Bopanna in the case Aureliano Fernandez versus State of Goa, termed it as a sorry state of affairs when she proceeded to issue a set of directions to strengthen the implementation of the POSH Act in order to address the challenges posed by sexual harassment. It was noted that sexual harassment brings down the self-esteem of a person, as well as mental and physical health, and how the uncertainty of who to approach under the Act for the redressal of their grievance plays a role in not reporting instances of sexual harassment, alongside the lack of confidence in the process and its outcome. In the case of Mukesh Yadav versus Union of India, Justice Kohli made a very significant observation with respect to juvenile offenders. That is, that their identities must be protected perpetually to ensure that no stigma is attached to them. The observation was made in a writ petition filed by a constable whose service at the Reserve Police Force was terminated by the Railway Board on the ground that he had not disclosed the pendency of a criminal case lodged against him for an incident that took place when he was 12 years old. Justice Kohli, in her order, observed as follows: there was no good reason for the respondents to have insisted that the petitioner ought to have disclosed the information relating to the allegations against him pertaining to an offense that was committed during his childhood, where he was tried by the Juvenile Justice Board and subsequently acquitted. The concerned police officials ought to have refrained from revealing the information pertaining to the petitioner in the case in question, since he was a juvenile at that point in time. This was, in fact, a gross breach of the confidentiality contemplated under the Act. We now request Her Ladyship to hold forth on the topic, Judicial Perspective on Economic Offences and Corporate Malfeasance.
Very good evening to all of you. Justice Bambani, Justice Ohri, my former colleagues, Justice Veena Birbal, Justice Sudarshan Mishra, Ms. Rebecca John, Mr. Akshay Bandari, Mr. Harsh Prabhakar, founder members, and other members of the Center for Discourse, senior advocates, members of the bar, friends from the media, ladies and gentlemen. It is indeed an honor to address this gathering of some young and some not so young members of the bar on the topic of the day, the white-collar crime in India from a judicial perspective. Just as I was sitting on the dais and speaking to Justice Ohri and interacting with Ms. John, I was reminded of that lovely days of Delhi High Court when I think the first time that I presided over a criminal bench after Justice Yogesh Khanna moved in a few days on his appointment was with Justice Ohri, who sat with me. And of course, we've had the privilege of hearing many of you, particularly Rebecca and so many of us here, Vivek, and we have a number of us, Mr. Badwa, on the criminal side. And of course, we have senior advocates here, Mr. Khanna and Mr. Gupta, who are not so much into the criminal roster, but still frequently seen on that side. Internally, we used to call that block, we had virtually the criminal block, because all the matters in that block were either single or division bench of the High Court, which was that block, and of course the new block, which is so up to date, and more like internally, as a joke, we'd call it T3, because it just felt you were taking off somewhere. So all those fond memories are coming back now that I've scorned myself in the Supreme Court. Just by the way, there is another T3 there, which is the courts at the back, starting from court number 10 and backwards, which we call, because of the walking distance that we have from the main lounge, Noida, and that's how we address that. So that's internal to us. We all have some little jokes in each court, which we all share frequently. This has been a venue of a lot of discourses, the IIC, for its convenience, for its distance, for the fact that it's like literally a stone's throw from where we are all located in court. It's always a pleasure to come back here and meet all of you. So coming back, as we delve into this subject that of the day, I propose to provide an overview of the current scenario, the judicial response, and the potential pathways for strengthening the legal mechanism to combat such offenses. White-collar crime, characterized by deceit and breach of trust, poses a significant challenge to our legal and economic systems. The concept of white-collar crime was introduced into criminology by Professor Sutherland in 1939. Professor Sutherland defined these crimes as those carried out by individuals of high social standing and respectability during their professional activities. He also extended this definition to include crimes perpetrated by corporations and other legal entities. White-collar crime can destroy businesses, it can ruin investors, and erode public trust in state and financial institutions. It has an incalculable social, physical, and psychological effect on the structure of the society. Key categories of white-collar crime encompass corruption, adulteration of food and drugs, counterfeiting, forgery, tax evasion, cyber crimes, money laundering, and many more. In the Indian context, the white-collar crime being invisible poses a significant challenge for detection due to the sophisticated and knowledgeable nature of its perpetrators. In contrast, the traditional crimes are more straightforward. They are more identifiable, typically involving direct force or aggression of some sort. Traditional crimes often stem from emotions like anger or revenge, and if cold-blooded, are meticulously planned and executed, sometimes with the help of persons with previous criminal history. Conversely, white-collar crimes are driven by greed. They are characterized by careful planning and execution by individuals with professional assistance. While white-collar crimes inflict reputational or financial damage and lead to substantial financial penalties when detected, traditional crimes result in physical harm and emotional damage. However, both types of crimes have a profound effect on the victims and the society at large. In India, white-collar crimes have manifested itself in many forms, affecting different sectors of the economy. High-profile cases such as the Satyam scandal, the Punjab National Bank fraud, the 2G spectrum cases have brought to light the pervasive nature of these offenses. These crimes erode public trust and have far-reaching implications of economic stability and governance. Coming to the classification of white-collar crimes, these crimes can broadly be categorized into individual and corporate offenses. Individuals are motivated by the pursuit of personal financial gain or enrichment, exploiting their knowledge and resources to commit these offenses, while corporate white-collar crimes involve coordinated action designed to advance the corporation's economic objectives. So what are the causes for these white-collar crimes? The primary drivers of this crime include greed, financial gain, and economic instability. The subtle and the deceptive nature of these crimes often leaves the victims unaware and easily deceived. The non-violent nature of white-collar activities often lead offenders to rationalize them as not really being crimes. Occasionally, financial desperation drives individuals to commit these crimes as a last resort to support their families. Perpetrators may even engage in these activities to satisfy their ego and their impulses. Finally, weak enforcement of existing laws often allows white-collar crimes to flourish, as the inability to strictly enforce regulations creates loopholes for such activities to proliferate. Now let's look at the judicial framework quickly. The legislative provisions, we have a robust legislative legal framework to tackle these crimes. Key legislations being the IPC, replaced by the Bharatiya Nyaya Sanhita that came into effect on 1st July. Sections 403-409 of IPC address offenses related to criminal breach of trust, fraud, and cheating, with the corresponding sections being 314 to 316 of the BNS. Prevention of Corruption of Act, Companies Act, Prevention of Money Laundering Act, Information and Technology Act, and there are some other relevant acts such as the Essential Commodities Act, the Industrial Development and Regulation Act, the Import and Export Control Act 47, and the Foreign Exchange Regulation Act. So what's the institutional mechanism? India has established various institutions to combat white-collar crime. Those include the CBI, the ED, the SEBI, the Serious Fraud Investigation Office. So looking at a detailed study of what kind of white-collar crimes exist and how do they manifest themselves in several ways and involve both minor and substantial sums of money. These crimes include bank frauds, they include bribery, black marketing, corporate fraud, inside trading, wire fraud, and opening of mule accounts. Bank frauds involve acts intended to deceive financial institutions. Bribery is conducted to exert undue influence over those in power or to expedite certain actions with the intent to defraud others. Black marketing includes the sale of illegal goods and illicit sale of legal goods for profit. Corporate frauds entails deceptive accounting practices that mislead investors, auditors, and analysts about a company's financial status. Insider trading occurs when someone trades a public company's stock based on significant non-public information. These crimes vary, but insider trading and wire fraud are the most common. Insider trading involves the exchange of securities by individuals possessing significant non-public information about a company. Depending on the timing and the nature of the transaction, this trading can be legal or illegal. On the other hand, wire fraud, often termed cybercrime, involves schemes to defraud or obtain money through false representations or promises using electronic communication. Wire fraud is characterized by using digital or electronic communication to carry out fraudulent schemes. A mule account is an account that is created by one person but operated by another person. These accounts are often used for money laundering and tax evasion. What are the challenges in prosecution? While white-collar crimes are not explicitly defined in law, they are addressed under various statutes. Driven by technological advancements and developments across multiple sectors, including industrial and commercial, the prevalence of these crimes have surged in recent years. Despite the robust legal framework, prosecuting white-collar crimes presents several challenges, and let me touch about just a few of them. Complexity and technicality. White-collar crimes often involve complex financial transactions and technicalities requiring specialized investigation and prosecution knowledge. Evidentiary issues. Gathering concrete evidence for white-collar crimes can be arduous given the sophisticated methods offenders employ to conceal their activities. Transactional nature. Many white-collar crimes have cross-border implications, necessitating international cooperation and coordination to address and mitigate potential misconduct within the organizations. Delay in the judicial process. The Indian judiciary is currently grappling with a backlog of over 3 crore cases. In this context, efficiently resolving white-collar crimes can present a significant challenge. To address it, it is critical to consider establishing fast-track courts dedicated to expediting resolution of white-collar crimes. Such courts may be, once established, can issue a final ruling. The decision should be binding on parties who should be prevented from relitigating the same issues correspondingly in other fora. Some cases of white-collar crimes in India. India employs various laws to identify and prosecute white-collar crimes. I'll only touch upon Harshad Mehta's case. White-collar crime saga in India came under public gaze in 1988 with the Harshad Mehta case that demonstrated the pump and dump strategy. Known as the Sultan of Dalal Street, Mehta manipulated stock prices for personal gains. This artificial inflation led to a sharp market surge and a significant drop when the fraud was exposed. This case promoted the SEBI to subsequently issue regulations to prevent similar scams. The Satyam computer scandal. This scandal came into light in the year 2009 through a confession letter written by the founder and chairperson of the company, published in the daily newspaper, then the Times of India. The letter confessed to manipulation of books of account by overstating the assets and understating the liabilities. The books of accounts being a true reflection of a company's financial health, they act as an essential tool for the investors to rely on before investing their money. In this case, the account books were manipulated and fudged to cheat investors and shareholders. The whole scam involved approximately 14,000 crores at that point in time and is considered to be a prime reason that contributed to the recession faced by the markets in the year 2009. In this scandal, the SEBI hit back strongly, holding the founder of Satyam and 9 other primary associates as guilty of insider trading and indulging in fraud and unfair trade practices. SEBI directed the accused to pay about 3,000 crores within 45 days. It debarred them from accessing the security market for 14 years. It managed to do damage control and ensure that such a scam cannot ever occur again in such a volume, in such quantities. We have recently also, just in a passing, the Punjab National Bank fraud, where a diamond merchant is alleged to have orchestrated a fraud relating to letters of undertakings issued by the bank, Punjab National Bank. The matter is sub judice, I wouldn't say more than that, but the scam involves about $1.8 billion and remains one of the largest in India's banking history. Strengthening the judicial mechanism in this background. Specialized courts perhaps is one answer. There is a growing consensus on the need for specialized courts to address the unique challenges of white-collar crime. These courts, headed by judges, assisted with prosecutors having expertise in financial and economic offenses, would help in expediting case resolution and ensuring more effective adjudication. Use of technology. Leveraging technology is crucial in combating white-collar crimes. Advanced data analytics, artificial intelligence, blockchain technology are tools that can enhance detection of these crimes, investigations, and prosecution. The judiciary can also benefit from the digital case management system to streamline the processes and reduce the delays. Let us talk about capacity building. Continuous training and capacity building for law enforcement agencies, for prosecutors and judges are equally essential to keep pace with the evolving nature of white-collar crimes. Specialized training programs will equip stakeholders with the necessary skills and the knowledge to tackle these offenses effectively, to protect themselves from becoming victims of such a crime. We also need to strengthen international cooperation. Given the transnational nature of many white-collar crimes, strengthening international cooperation is critical for our country. India has proactively entered into mutual legal assistance treaties, MLATs, and bilateral agreements with several countries in this direction. Continued efforts can facilitate exchange of information, of collaboration in investigating and prosecuting cross-border crimes. So what's the way forward? Public awareness and education is a very important aspect. Raising public awareness about white-collar crimes and their repercussions is vital. Education campaigns can help individuals and organizations to recognize, to report suspicious activities. Additionally, promoting a culture of ethical conduct and corporate governance can be a deterrent to potential offenders. Corporate governance and accountability. Enhancing corporate governance standards and accountability mechanisms is bound to play a significant role in preventing white-collar crime. Strict enforcement of compliance regulations, transparency in financial reporting, and establishment of internal checks and balances can mitigate the risks and foster a culture of integrity within the organization. An important role is that of the whistleblowers. Whistleblowers serve as a critical line of defense against these crimes. Encouraging whistleblowing and providing adequate protection to whistleblowers will help uncover and address such malpractices. Legislation such as the Whistleblowers Protection Act of 2014 needs to be implemented effectively to safeguard those who expose these wrongdoings. In conclusion, white-collar crimes present a formidable challenge to India's judicial and economic systems, necessitating a nuanced and a comprehensive response. The fight against this crime requires a multi-pronged approach. The judiciary, supported by a robust legislative framework and dedicated institutional mechanisms, is pivotal in addressing these offenses. Establishing specialized courts assisted by experts in financial and economic crimes with lawyers well equipped to understand the nuances and to deal with them and grapple with the problem is essential for timely and effective adjudication. Leveraging advanced technologies, as I mentioned, data analytics, AI, blockchain, will enhance the ability to detect, investigate, and prosecute the white-collar crimes. Ensuring robust cybersecurity controls to address digital frauds, Effective management of third-party risks and compliance culture in financial institutions is essential. Digital case management systems can streamline the judicial process, reduce delays, and improve efficiency. Continuous training and capacity building for law enforcement agencies, prosecutors, and judges is critical for staying ahead of the evolving curve of these crimes. Discourses and interactions like the present one are also equally important for all of us to be updated, to be aware, and be able to implement whenever the occasion arises and execute effectively such of the legislations that are already available in the legislative book. So strengthening these areas can help build a more resilient and a transparent legal system, and that upholds justice, upholds integrity, mitigates the impact of white-collar crime, and fosters a society where trust and accountability are paramount. I may conclude by quoting Justice Thakkar, who had authored a judgment of State of Gujarat versus M.J. Pawal and had observed in the context of white-collar crimes that, and I quote, "The entire community is aggrieved if the economic offenders who ruin the economy of the state are not brought to book. A murder may be committed in the heat of a moment on passion being aroused. An economic offense is committed with cool calculation and deliberate design with an eye on personal profit regardless of the consequences to the community. A disregard for the interest of the community can be manifested only at the cost of forfeiting the trust and faith of the community in the system to administer justice in an even-handed manner without the fear of criticism from quarters which view white-collar crimes with a permissive eye, unmindful of the damage done to the national economy and the national interest." Thank you for your attention.
We are grateful to Her Ladyship for gracing us with her wisdom. We will now have Justice Manoj Ohri speaking on the next topic. Justice Ohri did his graduation and post-graduation in physics from the University of Delhi in 1990 and 1992 respectively. His lordship did his LLB from the Campus Law Center in 1995 and enrolled as an advocate with the Bar Council of Delhi in the same year. His lordship then completed a course in English and EC Commercial Laws from the College of Law at York, United Kingdom on the British Chevening Scholarship. His lordship was appointed as panel counsel and later as senior panel counsel for the Union of India in the Delhi High Court. He was also appointed to represent the GNCTD on the criminal side and CBI in the Delhi High Court. In August 2014, his lordship was designated as a senior advocate. His lordship was elevated as a permanent judge of the High Court of Delhi on 20th November 2018. His lordship, in Ramesh Chandra Kathuria's case, upon cross-referencing the principles of vicarious liability as contained under the Negotiable Instruments Act with certain other legislations, including the Delhi Excise Act, held that wherever an offense is committed by the company, the same must necessarily be made and accused, in absence of which prosecution against its managing director cannot be maintained. In Dinesh Singh Kushwaha versus Directorate of Enforcement, in the context of a bail application under the Prevention of Money Laundering Act 2002, his lordship pertinently observed that mere transfer of money from one layer to another does not ipso facto mean that the subsequent layer was aware of the money being proceeds of crime. For establishing the factum of awareness of money being proceeds of crime within the various layers, certain connecting evidence is required, and mere accusations cannot be the sole basis for confirming the same. Recently, His Lordship, in Rashmi Goyal versus Mahalakshmi Fabrics, upon examining the statutory provisions under the Companies Act 2013 and its allied rules, held that in the absence of adequate averments in the complaint, the prosecution of a company secretary for the offense punishable under Section 138 of the Negotiable Instruments Act would be an abuse of process of law. We now request His Lordship to grace us with his eloquence on the topic, Contemporary Economic Offences in India, Issues and Challenges.
Namaskar and good evening. Honorable Justice Hima Kohli, Justice Bambani, Justice Birbal, Justice Mishra, Madam Neelu Kohli, Ms. Rebecca John, Senior Advocates, members of the bar, ladies and gentlemen. It's a distinct pleasure to speak to this distinguished audience on a matter of this immense public importance. Today I feel proud and happy to share the stage with Justice Kohli, with whom I started my journey on the bench. I must confess that I agreed to attend the event as a speaker with some trepidation due to the office I hold, since today's topics are subject matter of alive judicial debates in courts. So I disclaim at the outset that the views shared by me today may not be held against me if some of you may find them to be inconsistent with the judgments that I already delivered or I may deliver in future. At the same time, I sincerely believe that as a person and more importantly as a judge, that one must keep evolving with time and learn to challenge their own beliefs to keep evolving. Under the comfort of this disclaimer, I'll now share my views. Some of parts of my speech you might feel elementary for this experienced audience, but I can't help talking about them as they lend a structure to this speech, so please bear with me. White-collar crime is not new, but may have its origin dating back to 18th century. The South Sea bubble of 1720 was the world's first financial crash. It was world's first Ponzi scheme. A British joint stock company by the name the South Sea Company was founded in the year 1711 by an Act of Parliament. It was a public and private partnership that was designed by way of consolidating, controlling and reducing the national debt and to help Britain increase its trade and profits in America. To enable to do this, in 1713, it was granted a trading monopoly in the region. Its business was to provide African slaves to Spanish and Portuguese Empire. In 1718, to augment the profits, the governorship of the company was taken by none other than King George himself, and the company took over the national debt. This led to inflation of company's stocks. The stocks were returning 100%. The company lacked fundamentals, and because of what we now call insider trading, the stocks were artificially inflated. Eventually, the bubble burst and stock prices crashed from £1,000 to £124. Investor and public both were ruined. Amongst the losers was the most eminent scientist of that time, Sir Isaac Newton, who, as per today's worth, lost equivalent of £40 million. He remarked that he could calculate the motions of the heavenly bodies, but not the madness of the people. Even the genius of Isaac Newton could not see the deception of an economic offense. Perhaps he forgot the fall of the apple. Perhaps his third law of motion, that for every action there is an equal and opposite reaction, could describe the bubble burst. The South Sea bubble led to the Bubble Act of 1720, which may be cited as an example of an effort by the legislature to deal with fraud on a big scale perpetrated by unscrupulous persons. 2 centuries later, another eminent scientist, the Nobel laureate Albert Einstein, invested significant portion of his Nobel Prize money in stocks, but lost it in the 1929 stock market crash. Einstein could precisely predict bending of light near a star, but realized that money matters were beyond his comprehension. After winning the Physics Nobel Prize in 1930, C.V. Raman lost a significant chunk of his prize in an investment in 1940s that turned out to be a Ponzi scheme. In a similar dot-com bust in 2001, which had its ripple effect in India, my own maiden adventure to invest in IT stocks met a similar fate and brought me back to the safety of bank interest rate of 6%. I feel justified in claiming parity with the above distinguished people. Coming back to today's topic, our minds are familiar with traditional or conventional crimes such as murder, rape, theft. Economic offences form a separate category of criminal offences. These offences not only victimize individuals with financial loss, but also can have serious repercussions on the national economy. IPC remains the cornerstone of criminal laws in India. While it covers a broad spectrum of offences, its provisions were primarily designed to address traditional economic offences, crimes such as criminal misappropriation, breach of trust, dealing in stolen property, cheating, creating fraudulent deeds, concealment of property, forgery, falsification of accounts, and sale of adulterated drugs. Besides IPC, some other enactments were brought to deal with the issue of tax evasion and smuggling in the form of Central Excise Act in 1944, Income Tax Act 1961, and the Customs Act 1962. Over time, the nature and sophistication of economic offences has evolved, necessitating more specialized and nuanced legal instruments to combat them effectively. These crimes have some special features that make it different from traditional crimes and thus require special acts with special features. These special features are briefly special penal provisions, provisions modifying mens rea, provisions relating to liability of officers of company, vicarious liability, special rules of evidence, penalty by rules, special provisions as to sanction, etc. Case Santhanam Committee in 1962, followed by 29th Law Commission of India under the guidance of Justice J.L. Kapoor, and then 47th Law Commission of India headed by Justice P.B. Gajendra Gatkar, in its report made suggestions for all stakeholders and also urged the courts to treat economic offences as source of grave challenge to the material wealth of the nation. Some more enactments followed, like Coffee Posa in 1974, FEMA in 1999, Black Money and Imposition of Tax Act in 2015, IBC 2016, Fugitive Economic Offenders Act 2018. Even the definition of fraud in Section 447 of the Companies Act was expanded to include any act, omission, concealment of fact, or abuse of position that is intended to gain an unfair advantage over or harm the interests of the company, its shareholders and creditors. This brings all forms of corruption, deception, conflict of interest, and bribery under its purview. The SFIO, subsisting under the 2013 Act, is now a statutory entity with the authority to make arrests for fraud-related offences. Even in BNS, Bharatiya Nyaya Sanhita 2023, while provisions punishing an economic offence under the IPC have been retained, albeit under different numbered provisions, Section 111 has been introduced, which punishes organized crime and also lays down the definition of economic offence for the first time. Judiciary on its part has adopted a stringent approach due to serious implications these crimes have on the nation's financial health. In the words of Justice Chandrachud, the socio-economic offences have a tremendous potentiality for causing social and economic injury to the society, and such cases are therefore required to be treated with a different approach. Justice Nariman also said, the rule of law is the bedrock of democracy. It's imperative that law keeps pace with the changing society. Some of the judicial pronouncements also deal with the menace of economic offences, notable ones being Balakrishna Chaganlal Soni, where the Supreme Court observed in 1974 that social and economic offences stood on a graver footing in respect to punishment, and that if judicial institutions were not to be cynically viewed by the community, courts must help the process of conviction. To the similar extent were the decisions in Jagan Mohan Reddy, Vasanti Stanley, and Mohanlal Jitamlal Porwal. These observations underscore the judiciary's commitment to addressing economic offences with the gravity they warrant, considering their potential to destabilize the country's economic structure. Out of all the economic offences, the offence of money laundering has acquired a special status. Since the mid-1980s, global concerns about laundering criminal proceeds like drug trafficking funds used to finance terrorism prompted significant international action. UN Convention Against Illicit Traffic in Narcotic Drugs in 1988, UN Convention Against Transnational Organized Crime 2000, called for nations to criminalize money laundering. Established in 1989, the Financial Action Task Force made recommendations to strengthen global laws. In order to meet its multilateral international commitments and create an enabling regime to integrate our nation with the international structure, the Indian Parliament enacted PMLA in 2002 to combat money laundering, for which a global need was felt by the Committee of Nations. This one is the one which in recent past has hogged the limelight in terms of public debates by both laymen and expert commentators. I believe the public opinion does not question the need to have laws to deal with the menacing consequences of money laundering and international drug running, but the popular concern is the increasing sweep of PMLA, under which even the offences which are not strictly connected with the cross-border terror funding or drug running or human trafficking are prosecuted. Legislature in its wisdom has chosen to expand the width of PMLA beyond the original objectives. I must emphasize that the legislature is supreme and capable to imagine the challenges being faced by the nation and conceive the laws to tackle such challenges. However, howsoever noble the legislative motivations are, sometimes these does leave blind spots, hiding the constitutional guarantees of fundamental rights that a citizen enjoys. It is exactly what the judiciary is trained for, that is to see and remove these blind spots, to have a clear sight of the constitutional guarantees and stay clear of a potential constitutional mishap. The problem that judiciary faces is not the laws per se, but the application of laws to resolve the conflicts that such laws pose to the personal liberties and a common national objective like fight against corruption, international terrorism, and such debilitating offenses. The judicial pronouncements made on the subject are a product of such tightrope walking that is required to be done in such cases. Some judgments do appear to lean in favor of personal liberties at the same time, subservient to the large national cause of fighting corruption affecting the society at large. However, till date, largely the judicial wisdom has applied the law with a strict hand to send a strong message to all individuals in the society to subserve the larger good, even at the cost of some personal discomfort caused to the accused in the process. The Section 45 of PMLA, this provision has become matter of much judicial debate after Section 45, which introduces the twin conditions for granting bail to an accused. It is the basic tenet of law that liberty of an individual is sacrosanct, and every effort should be made to ensure that unwarranted interference or hindrance does not take place in its domain. However, at the same time, it was recognized that considerations of public interest and welfare could form grounds for valid interference with liberty of individual. While many laws and legal provisions contain essence of this balance between personal and public interests, most prominent among them is the system relating to grant of bail. In the words of Justice Krishna Iyer, the issue of bail is one of liberty, justice, public safety, and burden of the public treasury, all of which insist that a developed jurisprudence of bail is integral to a socially sensitized judicial process. These words underscore the importance of an effective and just bail system, whereby failure to do the same may prove to be disastrous for individual rights as well as legal system on a whole. Derived from the French word bailer, meaning to give or deliver, bail is a process wherein accused in the custody of law is released from the same into the custody of another individual, that is the surety, who undertakes to assure that the accused appears before the court of law as and when asked for. Such bail is usually complemented with monetary considerations, which may be foregone in a case where the surety fails to assure the presence of accused. In the ordinary course of things, the jurisprudential or basic principle guiding the exercise of power of grant of bail is that bail is the rule, jail is the exception. The CRPC and the BNSS contains within several distinct categories of bail, including but not limited to bail in bailable offences, bail in non-bailable offences, anticipatory bail, default bail. Each of these forms of bails have been incorporated with different aims, purpose in mind, and consequently, the manner and requirement of their grant also differ. However, even then, the jurisprudential principle continues to hold true for each of them. In cases involving special statutes, consideration for a grant of bail have been, however, made more stringent, in line with the aim of effectively addressing economic offences. Apart from mandating the prosecutor to be heard before such grant, these statutes also incorporate further conditions which need to be satisfied. They are: 1. There has to be reasonable grounds for believing that the accused is not guilty of such offence. 2. He is not likely to commit such an offence while being released on bail. The effect of incorporation of these twin conditions has been that the grant of bail in these cases has become difficult, with the accused heavily burdened with proving that conditions are fulfilled in his case. Some prominent laws containing such provisions are, as we all know, UAPA, NDPS, money laundering, and MACOCA. However, these twin conditions have not remained untouched from controversies. Conditions in PMLA came to be challenged in Nikesh Tara Chancha, where they were held violative of Article 14 and 21 and were declared unconstitutional. Subsequently, the provisions were reintroduced in the statute, albeit with some changes, and the re-enacted provisions came to be upheld in subsequent decision in Vijay Madanlal Chaudhary. At the same time, Supreme Court in its decisions like K. Najib, Jitendra Jain, Rabi Prakash, Man Mandal enunciated another crucial principle in the application of these conditions. While noting that intent and purpose behind the incorporation of these twin conditions in these special statutes, the court noted that another consideration that would and should play heavily upon the mind of the court in such cases should be the accused's right to speedy trial and justice, which forms an important facet of Article 21. It was held that in cases where there is an inordinate delay in the completion of trial of cases involving such special statutes, it would be against the constitutional ethos to let the accused languish in the jail. In such cases, these stringent twin conditions would no longer be able to sustain a case for continued incarceration of the accused and consequently would be entitled to grant of bail. What culminates from the discussion is that while such twin conditions have been found to be constitutionally justified, however, it is to be noted that these do not completely exclude the grant of bail, and further, in certain exceptional situations, these conditions can be disregarded to effectuate fundamental rights. Another significant departure in these special statutes relates to admissibility of the statement made to the investigating officer during the course of investigation. In the ordinary course of things, such statements have no value during the course of trial. Idea behind this legal principle was that there were strong apprehensions that if same are allowed to be considered as evidence, the police might take certain illegal acts in order to get such statements out of the accused persons. Further, Article 20, Sub-Article 3 of the Constitution incorporates the right against self-incrimination, which states that no person shall be compelled to be a witness against himself, which means no person shall be forced to give such evidence or statement which will have the effect of incriminating itself. Section 161, 162 of the CRPC provides that statements made to police officer reduced into writing would have no probative value during the course of trial except for the purpose of contradiction in terms of Section 145 of the Evidence Act. In cases involving special statutes, this proposition is diluted to the effect that such statements have been made admissible as evidence against individuals. Statutes like Companies Act, Customs Act, MACOCA, NDPS, and money laundering provides for such admissibility. This aspect of admissibility incorporated in special statutes has also been matter of consideration before various courts. In Naresh Sukhwani, while dealing with provisions of Customs Act, it was observed that officials acting under the aforesaid statute cannot be termed as police officers. Later, in Tufan Singh, in 2021, while dealing with Section 67 of the NDPS Act, the Supreme Court observed that the statements made to officials while acting under NDPS would not be admissible in evidence. The specialized statutes enacted with the specific aim of tackling the highly detrimental economic offences have been in action for quite some time and have been the subject of substantial judicial as well as social discussion. Their implementation and results are there, with some turning at them as major success while others raising concerns. The issue of twin conditions is again before the Supreme Court in a review. As we continue to navigate these complex issues, it is crucial to remember that our legal and judicial system have evolved to address these challenges. In this ever-changing landscape, we must be vigilant, adaptable, and committed to upholding justice. It is beautifully encapsulated in Sanskrit words, Parivartanamev Sthirmasti, that meaning change is constant. In closing, I leave you with these insightful words of Justice P.N. Bhagwati. The law must constantly adapt itself to changing needs of society and respond to its aspirations and its expectations. Let us commit to ensuring that our fight against economic offences is transparent, fair and just, reinforcing the trust of citizens in the legal system, which can only be achieved by assuring the citizens the observance of the constitutional guarantees by the judiciary. I was tasked by the organizing committee to keep the stage warm after the erudite and insightful speech of Justice Kohli, and before the domain expert who follows me, to share a more experienced perspective. I hope I have fulfilled the task. I thank all the office bearers of Center for Discourse on Criminal and Constitutional Jurisprudence for organizing the thought-inspiring discourse, as well as for giving me an opportunity to share my views. Thank you.
We are thankful to His Lordship for this illuminating lecture. Our next speaker is Ms. Rebecca M. John, Senior Advocate. Ms. John enrolled with the Bar Council of Delhi in 1988, after which she immersed herself in criminal law. In 2013, she became the first woman to become a senior counsel on the criminal side. Rebecca John has also served as a statutory member of the Internal Complaints Committee of the High Court of Delhi, which deals with sexual harassment complaints. Recently, she has been engaged as a legal expert for a forthcoming report to be published by the Clooney Foundation for Justice. She has conducted a wide range of criminal trials and appeals dealing with offenses under the Indian Penal Code, special statutes like the Unlawful Activities Prevention Act, Prevention of Corruption Act, Prevention of Money Laundering Act, amongst others. Over the years, she has represented accused persons as well as victims. Among the long list of cases to her credit are the 1992 security scam cases, where she represented Harshad Mehta and his family members, the Jain Hawala cases of 1996, where she represented C.K. Jafar Sharif, the 2G Spectrum case, where she represented Sanjay Chandra, Managing Director of the Unitech Group of Companies in the CBI matter, and Ms. Kanni Mozi in the case filed by the Enforcement Directorate, the Aircel Maxis case, where she represented Mr. Kalanidhi Maran, Rajesh and Nupur Talwar in the Arushi Talwar murder case, cricketer Sri Sant in the IPL match-fixing case, the Hashimpura massacre case, where she represented the families of the 45 victims of crime, the Ankit Saxena murder case, where she has been appointed as the special public prosecutor, and many others. In her appellate practice in the various high courts and the Supreme Court, she has represented, amongst others, the Steel Authority of India, workers of the Maruti Union, student leader Kanhaiya Kumar, journalist Rajdeep Sardesai, filmmaker Raju Hirani, former chief of SEBI Chitra Ramakrishnan, Rita and Natasha Singh of the MESCO Group of Companies, and Veer Singh of the Max Group of Companies. She is regularly called upon by courts to assist them as an amicus in matters involving important questions of law, including the constitutional validity of Exception 2 to Section 375 of the Indian Penal Code, otherwise called marital rape, and for the formulation of rules and guidelines for the service of summons on witnesses and accused persons residing abroad. She is presently a statutory member of the Delhi High Court Legal Services Committee. She has contributed a chapter on the jurisprudence of death penalty in the upcoming publication, Supreme Court at 75, to be released by the Supreme Court to commemorate 75 years of the court. Ms. John will be speaking on the topic, Diminishing Rights of an Accused under Special Statutes.
I don't think my clients would have been particularly impressed by that long list which was cited just now. So when Harsh Prabhakar came to me and said, choose your topic, it was a no-brainer that I chose diminishing rights of accused persons under special statutes. I'm conscious this is a Wednesday evening and all of us have to go back to work, so I'll get down straight to the topic. Criminal law today is overwhelmed by certain special statutes, all of which deviate from the procedure prescribed in the Code of Criminal Procedure 1973, now replaced by the Bharatiya Nagarik Suraksha Sanhita 2023. However, what is common to all these special acts is that they have diminished the rights of accused persons and have almost given unbridled power to the prosecuting agencies, which is only one of the two sides before a court of law. The absence of a level playing field can result in consequences that may lead to the charge, is India becoming a police state? Alarmist as this may sound, my address today relates specifically to the absence of procedural safeguards with respect to special statutes that are in direct conflict with Article 21 protections of the Constitution of India. I will speak on the near impossibility of getting bail with respect to these statutes, the unhealthy practice of staying bail orders,
the admissibility of statements under Section 50 of the PMLA and other provisions like Section 18 of MACOCA, which may be in conflict with the exceptions carved out in Sections 25, 26, and 27 of the Indian Evidence Act, now 23 of the Bharatiya Sakshya Adhiniyam. The weaponization of 173(8) of the Code of Criminal Procedure, now Section 193(9) of the BNSS, the complete impunity with which incomplete charge sheets are filed, and the lack of fair disclosure by the prosecution at the stage of filing of complaints and charge sheets by statutory agencies. The presumption of innocence is a bedrock of the criminal justice system, of which the most foundational principle is bail, not jail. The object of bail is to secure the presence of the accused person during trial. The approach of the court in examining applications for bail must necessarily hinge on two issues: whether the arrest was necessary and legal, and whether continued incarceration of the accused defeats his right to a fair trial, particularly since pretrial incarceration must never be punitive in nature. These principles are of particular significance when dealing with special statutes like UAPA, PMLA, NDPS, MACOCA, and Section 212(6) of the Companies Act, which place extraordinary restrictions on an accused before he can be released on bail. The entire endeavor of the prosecuting agencies and the accused is focused on this one aspect of the criminal justice system. I sometimes wonder whether this is a deliberate ploy which keeps all stakeholders reasonably occupied. The prosecuting agency spends all its time contesting bail applications. The defense is happy to spend most of its time arguing bail applications, and the court invests a substantial amount of time adjudicating bail applications. If, on the other hand, there was less contestation at this stage, it would lead to a more efficient criminal justice system, inasmuch as the entire concentration of the stakeholders would be on an effective conclusion of trial. Today, trials have been left by the wayside and have become inconsequential, as they hardly, if ever, proceed within a reasonable time frame, and in any event, when tested, the allegations are often found to be unsustainable, resulting in acquittals. So what are the twin embargoes that diminish the rights of accused persons in special statutes? The conditions for grant of bail in PMLA, the NDPS Act, the Companies Act, demand that the court return a finding that the accused is not guilty of the crime and is not likely to commit any offense in the future. In UAPA, the standard is that the allegations against the accused are not prima facie true. This is something that goes against settled jurisprudence pertaining to bail in India and is perhaps designed to keep an accused in custody for long periods of time. When the statute provides for such stringent conditions for the grant of bail, it is left to courts to protect the liberty of citizens. Recognizing the near impossibility of certifying at the stage of bail that an accused is not guilty or that he is unlikely to commit an offense in the future, the Supreme Court in Ranjit Singh versus State of Maharashtra, 2005, Volume 5, SCC 294, held while dealing with Section 21(4) of MACOCA, that the presumption of innocence is a human right. Article 21, in view of its expansive meaning, not only protects life and liberty, but also envisages a fair procedure. Liberty of a person should not ordinarily be interfered with unless there exist cogent reasons thereof. Subsection 4 of Section 21 must be interpreted keeping in view the above-mentioned salutary principles. Giving an opportunity to the public prosecutor to oppose an application for release of an accused appears to be a reasonable restriction, but Clause B of subsection 4 of Section 21 must be given a proper meaning. It was further held that the wording of 21(4) of MACOCA does not mean that the court must arrive at a positive finding that the applicant is not guilty of an offense under this Act. The Supreme Court recognized the absurdity of the twin requirements, also for the reason that having granted bail to an accused person on the ground that he is not guilty of an offense, it would be impossible for the prosecution to obtain a judgment of conviction. Section 21(4) of MACOCA, the Supreme Court held, must be construed reasonably so that the court is able to maintain a balance between a final judgment and the order granting bail pending trial. In Nikesh Tarashan Jha versus Union of India, while dealing with the unamended Section 45 of the PMLA, the Supreme Court read down the twin provisions to be satisfied under 45(1) of PMLA and held, and I quote, "We must not forget that Section 45 is a drastic provision which turns on its head the presumption of innocence, which is fundamental to a person accused of an offense. Before application of a section which makes drastic inroads into fundamental rights of personal liberty guaranteed by Article 21 of the Constitution, we must be doubly sure that such provisions furthers a compelling state interest for tackling serious crime. In the absence of any such compelling state interest, the indiscriminate application of provisions of Section 45 will violate Article 21 of the Constitution," unquote. However, subsequently, Parliament attempted to revive the twin conditions with the 2018 amendment, and the constitutional validity of the same was upheld by the Supreme Court in Vijay Madan Lal Chaudhary, 2022 SCC Online, Supreme Court 929. It held that once the defects noted by the court had been cured by Parliament by enacting the Amendment Act of 13 of 2018, there was no need to delve into the twin conditions, and that they were constitutionally valid. Thus, the twin conditions that are invoked before bail is granted in PMLA, Makoka, the NDPS Act, which require courts to certify that the accused is not guilty of an offense and is unlikely to commit any offense in the future, has resulted in a deeply restrictive interpretation of these provisions, notwithstanding the complete clarity with which the Ranjit Singh Brahmjit Singh Court assessed the twin conditions in Makoka and leaned in favor of granting bail. Unlike PMLA, Makoka, NDPS, and Section 212 of the Companies Act, the restrictions in UAPA are less onerous inasmuch as it does not require certification from the court that the accused is not guilty of a crime, but requires the prosecution to establish a prima facie case against the accused, which, if established, will severely limit the right of the accused to be released on bail. There has been a partial recognition that these provisions violate the constitutional safeguards and the disproportionate burden placed on an accused person in seeking bail, particularly when trials are not concluded within a reasonable time frame. A three-member bench of the Supreme Court in Union of India versus K. N. Najib held that it is thus clear that the presence of statutory restrictions like 43D5 of the UAPA per se does not oust the ability of constitutional courts to grant bail on grounds of violation of Part 3 of the Constitution. The Najib jurisprudence came into play after the Supreme Court passed a judgment interpreting 43D5 of the UAPA in NIA versus Zaroor Ahmad Shah Watali. In this case, the Supreme Court overturned a detailed order passed by the Delhi High Court, granting bail to the accused by essentially holding that if the prosecution has placed a charge sheet and documents which set out a prima facie case against the accused, he is not entitled to bail. But to determine whether a prima facie case has been made out, the Watali court prohibited the court from assessing the credibility of the evidence placed by the prosecution. This essentially meant that once the prosecuting agency put together allegations, the court was prohibited from assessing its probative value. This led to many prisoners suffering years of incarceration before the extreme imbalance was corrected in another judgment of the Supreme Court, titled as Vernon versus State of Maharashtra, passed in 2023. In Vernon, the Supreme Court held that the test for prima facie true in 43D5, laid down in Zaroor Ahmad Shah Watali, must include a judicial scrutiny of the probative value of the evidence relied upon by the court. The court held that what Zaroor Ahmad Shah Watali said, what this ratio contemplates is that on the face of it, the accusation against the accused ought to prevail. In our opinion, however, it would not satisfy the prima facie test unless there is at least surface level examination of the probative value of the evidence at the stage of examining the question of granting bail, and the quality of probative value satisfies the court of its worth. Even after the Vernon court had somewhat restored the balance in favor of an incarcerated accused under UAPA, in Gurvinder Singh versus State of Punjab, a judgment delivered in early 2024, an extraordinary pronouncement was made when the court held, and I will quote, "The conventional idea in bail jurisprudence vis-a-vis ordinary penal offenses that the discretion of court must tilt in favor of the oft-quoted phrase, bail is a rule, jail is the exception, unless circumstances justify otherwise, does not find any place while dealing with bail applications under UAPA. The exercise of the general power to grant bail under UAPA is severely restrictive in scope. The form of the words used in proviso to section 43D5 that within quote shall not be released in contrast with the form of the words as found in section 437(1) CRPC may be released suggests the intention of the legislature to make bail the exception and jail the rule. Interestingly, the Gurvinder court did not consider the Vernon judgment and attempted to dilute the impact of the three-member judgment in Najib. Soon thereafter, however, the Supreme Court once again reassessed and endorsed the Najib view and the Vernon view in Shoma Kanti Sen versus State of Maharashtra. In Shoma Kanti Sen, the Supreme Court reiterated that bail was a fundamental right even in the face of the restrictive conditions in section 43D5. It further held that the judgment in Gurvinder Singh did not dislodge the access of reasoning on the constitutional ground in K. Najib. The court in Shoma Kanti Sen relied on Vernon and on an analysis of the probative value of the prosecution evidence, held that no prima facie case was made out and released the accused on bail. Due to the statutory embargoes in these special statutes and the near impossibility to get bail as a consequence thereof, the Supreme Court has now begun to endorse judgments that seek to ensure that the prosecution adheres to all constitutional safeguards. In Pankaj Bansal versus Union of India, the Supreme Court placed emphasis on the constitutional right of the accused to be informed of the grounds of arrest in writing, thereby upholding Article 22(1) of the Constitution. In Prabir Purakastya, the Supreme Court took exception to the accused being produced by the prosecution at 6 a.m. in the morning for remand in the absence of his lawyer of choice and ultimately declared his arrest to be illegal as he too had not been furnished the grounds of his arrest. These course corrections are necessary if the criminal justice system were to uphold constitutional protections and mandates. Recently, a disturbing trend has emerged of courts staying bail orders upon the asking of investigating agencies. More recently, the Honorable High Court of Delhi stayed a bail order of a high political functionary without examining the impugned order granting bail or the cancellation of bail petition. Even where bail orders in sensitive cases are ultimately upheld, courts often rule that the impugned orders would not be used as precedents in order to protect the interests of the state. This trend of staying its own beneficial orders was prevalent in Bombay, but it seems to have spread to all jurisdictions given the almost muscular protestations made by state agencies when orders are passed against them. Let me emphasize there's no provision in the Code of Criminal Procedure that permits a court to stay its own order on bail or order of acquittal, and this practice must be discontinued forthwith. It is one thing for a superior court to stay the order of an inferior court, but for the court passing the order, no request for keeping the order in abeyance must be allowed. While examining diminishing rights of an accused person, particularly in connection with special statutes, another tactic that has largely gone unchecked, employed by prosecuting agencies, needs to be highlighted. That is the use of Section 173(8) of the Code of Criminal Procedure, now 193(9) of the Bharatiya Nagrik Suraksha Sanhita. The practice by investigating agencies of filing incomplete or piecemeal charge sheets based on partial or incomplete investigation with the sole object of closing the right of default bail continues to plague the operation of Section 167 on the ground. A fair approach to assessing completeness of a charge sheet would be to see whether the prosecution is merely seeking time through the original charge sheet to continue its investigation, or whether the investigation is actually complete. Strictly speaking, Section 173(8) of the Code, which empowers the police to conduct further investigation, should be invoked only when the investigating agency encounters fresh material, that is, material it did not have access to at the time of filing the original charge sheet. However, when an investigating agency informs the court that it would be filing supplementary charge sheets based on further investigation, the court should decide the issue of completeness of the original charge sheet before taking cognizance. Judicial scrutiny is critical since it directly affects fair trial rights of the accused. The issue of a complete charge sheet bears significance for two reasons. Firstly, the filing of a charge sheet within the period of 60 or 90 days from the date of arrest, as provided in Section 167 of the Code of Criminal Procedure, defeats the right of default bail of an accused who is in custody. Secondly, the magistrate is empowered to take cognizance of an offence and issue summons to an accused based on the charge sheet, which commences the process leading to a trial, and thus has severe limiting implications for the accused. Most complaints filed under PMLA or charge sheets under UAPA relate to complex transactions. Under UAPA, the prosecution has a right to seek an extended period of detention from 90 to 180 days, and this allows it additional time to file a charge sheet. Notwithstanding such additional time limits, most UAPA investigations are not completed even within the extended period of time. Any practitioner of criminal law is aware of the fact that every prosecuting agency files a charge sheet which it terms as complete within the statutory period, but continues with further investigation, which further investigation relates to the original transaction and the original offenses that are being investigated. It would therefore be disingenuous to suggest that supplementary investigations conducted by investigating agencies have nothing to do with the already charge-sheeted accused, particularly when materials collected in the supplementary investigation is used directly against the charge-sheeted accused. While it is not my argument that investigating agencies cannot file additional or supplementary charge sheets based on further investigation, it is my argument, however, that the completeness of the original charge sheet must be determined by the court at the stage of taking cognizance. And if such charge sheet is found to be essentially incomplete, courts must not hesitate to invoke the provision for statutory bail in favor of the charge-sheeted accused. What is happening now appears to be a win-win situation for the prosecution. Endless investigations are carried out with no judicial oversight, and the accused person continues to languish in jail. Thus, constitutional courts have a duty to balance the fundamental right of liberty of an accused person with the right of the prosecution to investigate serious crimes. But while doing so, it must not reduce provisions like 167 to a mere procedural formality, the charge sheet to a mechanical list of particulars, and the right of default bail to an arithmetic of 60 or 90 days. Justice Ohri spoke about the admissibility of Section 50, which is an exception to Sections 25, 26, 27 of the Indian Evidence Act, and Section 18 of MACOCA, where certain confessions are admissible provided they are recorded by officers of a particular rank. General law states that confessions made to police officers are inadmissible in evidence as per Section 25 of the Evidence Act. Section 27 provides that confessions made while in police custody are inadmissible unless made in the immediate presence of a magistrate. 27 is the exception to the rule, where only that part of the statement that leads to the discovery of a fact recovery would be admissible in evidence. These sections are now amalgamated and form part of Section 23 of the Bharatiya Sakshya Adhinayam 2023. The legislature, in its wisdom, provided for these statutory safeguards, keeping in mind that confessions may be coerced from an accused person. Some special statutes like PMLA, MACOCA, NDPS provide for recording of confessions of accused persons. While Vijay Madan Lal Chaudhary holds Section 50 statements recorded under PMLA to be admissible, it, however, concedes that once an accused has been arrested, the consequences of Article 23 of the Constitution or Section 25 of the Evidence Act may come into play to urge that the same being in the nature of a confession cannot be proved against him. Similarly, in Sanjay Jain versus ED, the Delhi High Court held that a confessional statement of a co-accused under Section 50 of PMLA is not a substantive piece of evidence and can be used only for purposes of corroboration in support of other evidence to lend assurance to the court in arriving at a conclusion of guilt. Despite the apparent reading down of Section 50, they continue to be used to extend periods of incarceration and face no embargo on the usage, unlike statements recorded under Sections 161 or 164 of the Code of Criminal Procedure, where its usage is limited to prove contradictions or omissions. As I said, under Makoka, Section 18 provides for confessions to be used against an accused person, and the Supreme Court has held this to be valid, provided, of course, that the person before whom the confession is recorded under Section 18(1) is a person of a particular rank. To my mind, Section 18, with or without safeguards, goes against the constitutional protection offered under 23 of the Constitution, and these provisions ought to have been struck down as being violative of the Constitution. Fortunately, the Supreme Court in Tufan Singh has now made it clear that the officers vested with powers under 53 of the NDPS Act are police officers within the meaning of Section 25 of the Indian Evidence Act, as a result of which any confessional statement made to them would be barred by Section 25 and cannot be taken into account to convict an accused. Another area that requires urgent attention from constitutional courts is with respect to fair disclosure by the prosecution in placing documents and statements favoring both sides of the litigation. One of the most important stages of a case is the supply of documents to an accused in terms of Section 207 and 208 of the Code of Criminal Procedure. Only if an accused person knows all the material that is there against him can he defend himself adequately. Further, it is the duty of the prosecuting agency to place all material along with the charge sheet, whether it is inculpatory or exculpatory. More often than not, material that is beneficial to the accused is suppressed by investigating agency. That is why it becomes extremely crucial for courts to direct investigating agencies to provide documents not relied upon to the accused persons. In Siddharth Vasisht, the Supreme Court had recognized that fair disclosure by the police is part of the fundamental right of the accused to a fair trial under Article 21. Further, in Suo Motu Writ Criminal Numbers 1 of 2017, with regard to issuance of directions and guidelines regarding inadequacies and deficiencies in criminal trials versus the state of Andhra Pradesh, the Supreme Court made it amply clear that the magistrate should ensure that a list of other materials, such as statements, objects, documents that have not been relied upon, should be furnished to the accused. This is not a foolproof measure, since exculpatory material is often camouflaged in police records and not formally seized. Further, the court does not specify any consequences for prosecution for non-disclosure. However, this narrow safeguard was narrowed down even further by the Supreme Court in P. Punnaswamy v. State, where it held that the accused may seek supply of unrelied upon documents and other exculpatory material through Section 91 of the Code only after framing of charge. Punnaswamy effectively curtails the right of the accused to seek and use these unrelied upon documents, usually favoring them to effectively argue for bail or discharge. Thus, unlike the Brady disclosures standard in the United States, which requires disclosure of all materials to the accused, even when not requested, and non-compliance being a violation of the Due Process Clause of the US Constitution, the Supreme Court of India recognizes a much narrower standard. This compels the defense to operate on a turf of the prosecution at the stage of framing of charge, which squarely affects their fair trial rights. Ultimately, these are very important conversations that are necessary for the functioning of a robust criminal justice system. The acknowledgement of the diminishing rights of the accused and the role played by courts in such a shrinking space is vital. It is an aspect which requires keen observation and constant course correction. It is also essential that prosecuting agencies and state councils inhabit their roles with a sense of deeper responsibility. It is, after all, settled law that since stringent procedural provisions come into play, the invocation of special statutes must be done with the utmost care and consciousness. The presumption of innocence must never be overturned, and other fundamental rights cannot and must not be defeated by the extraordinary conditions and provisions contained in these special statutes. Thank you.
We are grateful for Ms. John's keen observations and inferences. We also wish to thank Mr. Rakesh Kumar Khanna, Senior Advocate, former Additional Solicitor General of India, Mr. Mohit Mathur, Senior Advocate, Mr. Brij Bhushan B.V. Gupta, Mr. N. Hariharan, Mr. Vivek Sood, Senior Advocates, as well as the presiding and former judicial officers who are present among us today for gracing this occasion with their presence. Thank you everyone for taking out the time to be here with us at our second session. We hope for your continued blessings, support, and encouragement. I now request all the committee members to come on stage to take a photo with the speakers. Thank you. We also wish to thank Justice Waziri for gracing us with his presence.
Make a good semicircle. Thank you.